All right. Hello, everyone. My name is Zach Miller, and I work in the Slice office here at Carnegie Mellon. I want to thank you all for attending this workshop on leases and tenant rights. This workshop will be led with our attorney, Matt Feinman, who works with us through the CMU Student Legal Consultation Program. The Legal Consultation Program is a program that is sponsored by the Graduate Student Assembly, the Provost Office, and the Undergraduate Student Senate. The program offers free legal consultations in 20-minute increments to students who have issues they would like to discuss. Essentially, you sign up for an appointment on Calendly, and you can meet with either Matt Feinman or another attorney we work with, Matthew Marcello, to discuss issues you have and receive some legal advice. The program is offered free to students. As part of that program, we are aiming to host about 10 workshops this year. This is the first workshop of the year. For your information, I am putting the link to our website in the chat right now, so that way you can all reference it if you need it. Again, today's workshop will be led by Matt Feinman. It will be recorded. There may be some time for question and answers at the end of this session. When question and answers come around, we will stop the recording so nobody's question or answer is in the recording. We also ask that for any questions and answers at the end, that you limit your questions to general questions only. We're not taking specific questions at this time about your particular lease or your situation. If you have specific questions that need answered, feel free to go to our website and make an appointment to meet with one of the attorneys to discuss that. All right, Matt, I'm going to turn it over to you.
Thank you very much. I appreciate it, Zach. Thank you, everybody, for joining us. As Zach said, my name is Matt Feinman. I am one of the two attorneys that does the student consultations every week. I am a solo practitioner. My office is in Oakland, just a mile from the school. I've been practicing in Pittsburgh for a number of years now, and one of my primary areas is landlord-tenant law. So that's the most number of questions that we get from students. It's not the only thing that students are limited to talking to us about, but it does turn out to be the primary area that we are asked to discuss, which is also why the majority of the workshops that we do have to do with landlord-tenant law. So what we're going to do today is a basics of landlord-tenant law, what to look for in a contract. We're going to talk a little bit about security deposit, the life cycle of the lease. As Zach said, if you do have questions, you're welcome to put them in the chat. At the end of this, I will stop the recording, but I would like to reiterate what Zach mentioned just a few minutes ago, which is please try to limit the questions to topics that I've discussed today, as opposed to my lease says X or my friend's lease, this is what happened. Those are situations that we would meet individually about. So I'm going to share this PowerPoint. So give me just a second to get this going. Hopefully everybody can see this. We are, like I said, we are going to discuss landlord-tenant law. I do want to make sure that it is aware the information in these slides is for educational purposes. This is not to be considered legal advice. And actually, if you give me just a second, I'm going to make one small change to our presentation. I apologize. I have a split screen set up, and I want to make sure that you can all see exactly what the presentation and not the speaker view. So hopefully, all right, it doesn't want to go to the speaker view, so I'm just going to keep it as it is, and we'll go from there. So the information here is set up to be just that. It's information. It is not legal advice. Again, please contact us if you have specific legal needs. Also, nothing here today forms an attorney-client privilege. So If you take information that you see here, you can't say, well, I spoke with an attorney who said X, Y, and Z. This is just basic legal information. We've been doing this with Carnegie Mellon for about 2 years now, both Attorney Marcello and I, and have had a lot of positive results with students. So we're happy to continue to do this. And again, if you have questions, please feel free to reach out. We are here for these consultations. So just to do a quick, what I like to call CMU Law School Contracts 101. There are 3 elements of any contract: an offer, an acceptance, and a consideration. An offer is, I will give you this if you do that. I'll pay you if you paint my house. I will give you a place to live if you pay rent. I will fix your car if you bake me a cake. The acceptance is, I agree to those terms. And then consideration is, something has to be given. You can't enter a contract, a one-sided contract, for nothing to go back and forth. So I give you money, you give me a place to live. I paint your house, you give me a cake. Whatever that may be, whether it's a good, a service, cash, anything like that. That's the fundamental basic of a contract. Now, the relevant sections of the lease. A lot of the answers that we give in our consultations, a lot of the questions that prompt those answers are all in the lease. Now, that's not to say that you aren't allowed to come and ask us questions. We absolutely want you to come and ask us questions. But we always encourage people to take a look at their leases before you schedule, because you may already have the answer. A lot of it comes down to morals and ethics, but you want to take a look at the relevant sections. Who are the parties? What is the length of your tenancy? Is it a 6-month lease? Is it a 12-month lease? Is it open-ended? Does it auto-renew? What's the security deposit? Are you paying the last month's rent up front? How much is your rent? Who pays utilities? Who's responsible for repair and maintenance? And how does the lease end? So I have screenshots from a lease. And I'm going to apologize if you can hear buzzing in the background. They have not cut the grass outside of my office in 2 months, and today is the day they have decided to start. So this PowerPoint, I don't know why it's not, why it's decided to not go full screen for me. But I do have in here, and it will be posted. I'm going to give it to Zach to post up online for us. I have in here sections on so residency and financials. Who's in charge of the lease? Who's the landlord? Who is the tenant? A lot of times the owner of the property is not the landlord. A lot of times the property manager may not even be the landlord. So you always want to know, who is the landlord? Who do I take my concerns to? And who should I be listening to? I have seen situations where owners and property managers don't always agree. And it's rare, but sometimes the owner will say, you can do this in my house. And the property manager says, no, you're not allowed to. Who do you listen to? Look at the lease and see who, it'll tell you exactly who to listen to. Who is the tenant? Is it just you? Is it you and your roommates? Do you each have separate leases? That makes a big difference from a legal standpoint, because if something happens and you're evicted, and they want to file suit, do they file suit just against you? Do they file suit against you and your roommates altogether? And there's a whole host of issues, and I believe we talk about that later, depending on how that is listed. So who is in charge of the lease and who is responsible for the lease? So here, this one's a little bit closer. Here's who the lease is. Here's who. Here's what the consideration is as well. The consideration is you are going to pay rent. They are going to give you a place to live. Initial term, renewal, and termination. Here's when it starts. Here's where it ends. There's a lot of times also parts that discuss whether or not it auto renews. Always look for those, and always look for those when you sign. Everybody has a smartphone now, or almost everybody has a smartphone. Everybody has access to a calendar of some sort, whether it's virtual or physical. Put it in your calendar when you have to renew, or when you don't want. If you don't want to renew, put it in your calendar when you have to cancel your lease if it auto renews. I have seen people who have signed a lease in August and they have to renew in January for the following August. You don't want to come to March and find out, I don't really want to stay here, but now I'm locked in for another year. Obviously, the coronavirus has changed a lot of things. I'm sure a lot of people online right now are curious about that. The courts have decided, and I can't guarantee this for every court, but we have spoken to the judges, and a lot of courts are looking to be very much more lenient on people who signed renewals or whose leases automatically renewed prior to the coronavirus. I'm not coming back to school. I'm not coming back on campus. I can't live there next year. They're a lot more lenient on letting people out of those leases. But take a look at those, because if you're signing leases now, you want to know, or even if you signed it in the last couple of weeks, you want to know exactly when your renewal period comes due. Because if you don't want to stay there next year, you may have to let them know by the end of this year. Then you have how much is your rent? How much is due each month? How much is due for the year? When is it due? When is it late? Those are all very, very big questions, and the court asks those questions. You know, if your rent is due on the 1st and you have a jerk landlord who files suit on the 2nd, every time you don't get them your check on the 1st, well, they can't charge you a late fee, but also those judges are going to probably throw those cases out. But the fact is, how much is the late fee and when does it come into play? You always want to know exactly when all of that is taking place. The security deposit. How much do you have to put down up front? And we are going to talk about the security deposit law a little bit more later on. But you have every right to know under the security deposit law where it's being held. Now, this lease that I pulled specifically says where they're holding the security deposit in escrow. I will say that 99% of leases that I have read, and just in the last probably, we'll call it 2 years since I started, since Tony Marcello and I have started at CMU, I've probably looked through 200 or 300 leases, if not more. I will say this is probably the only one that has said specifically where they're holding the security deposit, but you are allowed to know that. It's your money. The landlord's holding onto it, but it is your money. So you're allowed to know where it is, but make sure you know exactly how much it is. Because a lot of people guess. A lot of people come to me and they say, well, I think I paid a $1,200 security deposit, but I'm not sure. And it turns out, no, you didn't. You paid $1,000. You paid $800. Make sure that you know all that information. Who's in charge of utilities? This is a very, very, very big one. And utilities, for those of you who have not lived up north before, I moved to Pittsburgh 8 years ago from Florida. Heat was not a thing. I think my heater was on, if it was on 3 days a year, it was a cold year. So I didn't have to worry about a gas heater. I didn't have to worry about a furnace. Who takes care of that? Make sure that you know what utilities are coming into your place and who's responsible for them. If you are responsible for them, and many, many leases say that the tenant is responsible. If you are responsible for your utilities, you can get almost all of them put in your name. That way you get a copy of the bill. Your landlord will probably still get a copy as well, but you get a copy of the bill, you know exactly how much it is, and you know if there's anything going on. If your landlord is going to keep the utilities in their name, and usually all of the utilities except for the water bill can be transferred into your name. Apartment complexes are a little bit different, especially apartment houses. The houses that have been converted into about 6 or 8 rooms. Those are a little bit harder. They can't always transfer it over, but always ask anyway. If your landlord refuses to give you a copy of the bill, I'm sorry, let me rephrase that. If your landlord refuses to put the bill in your name, make sure that you get a copy of the bill, because you don't want to get your rent statement the next month, $1,200 for rent, $300 for electric, when normally your electric bill is $75. You need to know what's going on in those bills. And if you're responsible for them, you should always have a copy of them as well. Just make sure that you know who pays for it and make sure you know how to pay it, because you also don't want to have those utilities turned off either. Because if the utilities are turned off and it causes damage, that's on you to fix if the utilities are in your name. You want to make sure that it talks about what happens if you breach the lease, and also what happens if the landlord breaches the lease. What happens if somebody breaks the lease? And I believe a little bit later on we talk about we talk about ways to breach the contract, breach the lease, and sometimes that's okay to do. Sometimes it is absolutely okay to break your lease, but you want to make sure that you understand how to do that the right way and what will happen. So residential leases in Allegheny County, they cannot just enter a judgment against you. They have to take you to court if they want a judgment. But are they allowed to claim legal fees? The landlord-tenant law says no unless the contract says yes. So check and see if the contract says yes. Can they do what's called an acceleration of the rent? If you're 6 months in and so you've gone August to December and you don't pay January, can they sue you for January through July? Some leases say that they can. Find out what happens if you breach, but also find out what happens if they breach. What if the air conditioner stops working and it's not your responsibility? Some leases say that it is, but the majority of them say it's not. So if it's not your responsibility and the landlord does not fix it, what are your remedies? What can you do? And the law has a number of things that you can do, but see if the lease has anything as well. In those situations, typically you can, these are all after discussing things with your landlord and getting multiple refusals. You can pay to fix it and deduct it from your rent. You can stay somewhere else until it's fixed and deduct any charges. So if you stay at a hotel, deduct that from your rent. These are all things to come talk to us about before you do, but these are options for you as well. What if you want to leave before the lease ends? This is probably one of the most common questions we get. And I know that this is I believe this is the graduate student orientation. And I will say that it's usually graduate students who come to us with these questions because your program will end in December, but you've signed a lease through August. And now your landlord's gone back and said, well, I know I said you could sublet, but now I'm not going to let you. How can we, so then you come to us and say, well, what can we do? So this is the first place to check. What happens if you want to leave early? Sometimes they just charge you a 1 month vacancy fee and you're done. I will tell you that those leases that I see that say we charge you 1 extra month's fee and then that's the end of it, you're done. My recommendation is take it and go, because that's usually the best deal that you can get. But there are sometimes other options. And so that's one of the reasons that you'd come to us and talk to us about that. Your responsibilities for if you breach the lease, if the lease is broken by the tenant, what do you owe to them? This is all part of what we were talking about. What costs might you have to pay, depending on the situation. And again, all of these come with their own unique individual situations. I have, with the exception of talking to 2 roommates who didn't know that the other one was coming to talk to me, on another week, I have never heard the same situation twice. So all of these are unique situations. And if you are running into something like this where you need to break your lease, again, come talk to us ahead of time and we can go through all that with you. Joint and several liability. This is one that goes back. This is one of those legal fundamental issues that I wanted to make sure that I covered with everybody. At the beginning, I talked about how you want to make sure that you know who is on your lease. Is it just you or is it you and your roommates? So I'm going to give you a scenario. You move into an apartment with 2 other roommates. The reason I use that number is because in Allegheny County, in Pittsburgh actually specifically, you with minimal exceptions, you cannot rent a space with more than 3 people. So we'll go with a legal standard, and we'll say that there's 3 of you renting the property. And if you, roommate A, and roommate B, and you pay $1,200 a month, so each of you pays $400. If roommate B decides to stop paying rent, so now $800 a month is coming to the landlord. If you are all on the lease together, the landlord does not care how much money you pay, how much money tenant A pays, and how much money tenant B pays. The landlord doesn't care. What the landlord cares about is that they receive $1,200 per month, period. So if there's $400 that they're being shorted every month, they're going to take all of you to court. And they're going to say, all of you are responsible. And let's say they get a judgment for, let's call it $4,800. Your roommate B does not pay at all the entire year, 12 months, $4,800. You have a bank account with $10,000 in it. The landlord has every right, under joint and several liability, the landlord has every right to come to you and get their $4,800. Then you can go to roommate B and sue them for the money back. But it's a whole process you have to go through. Joint and several liability means that everybody who's on the lease and everybody who's being sued is equally responsible no matter whose fault it was. So keep that in mind. If you are an individual on an individual lease, you have a greater protection. Will the landlord do that for you? I don't know. I can't speak for all the landlords, and it really comes down to the individual landlord. But keep this in mind, and if you have the option to sign your own individual lease without having your roommates jointly and severally liable, it's the best opportunity for you to save yourself some grief down the road if a legal issue were to arise. And it limits your liability. Notices. So in the legal process, the landlord has to notify you if they're going to file an eviction, or if they're going to change any rules, or if they're going to do anything in your lease, whether good or bad. They need to give you some kind of a notice. They can ask you to waive away that notice. You can sign in your lease, it can say, I waive notice. If you're not paying your rent, they don't have to give you a notice before they file an eviction. They can just file it. The other reason that the notice section is there is, who do you need to let know? So again, let's go with an owner and a property manager. Who do you need to tell that you do or do not want to renew? And if you are supposed to tell the owner and you tell the property manager, and the two of them for whatever reason didn't communicate about it, you haven't properly notified the owner that you intend to stay, or that you intend to end your lease at the end of it and not renew it. So you always want to check the notice section. And if it's not in there, do not be afraid to call your landlord and say, if something happens, if I need to get a hold of you, if I choose to not renew, if I choose to renew, I need to know how to contact you. In the past few years, and I hate to say that it's only been the past few years, because I think the average age of our judiciary is a lot older than all of us. And I know I look it, but I promise I'm not that old. They up until about 5 to 10 years ago, they did not accept emails or text messages as proper notice. Now the courts have started to understand that you may never have a written conversation, a written on a piece of paper or typed on a piece of paper conversation with your landlord. You may only communicate through text. And if that is the way you always communicate, or if email is the way you always communicate, the courts will accept that as a proper form of notice for your landlords to contact you and for you to contact your landlords. And then finally, the signature. You want to make sure that you sign the contract. The biggest argument that comes to me when it comes to signatures is, I never received a copy of the lease with the landlord's signature on it, therefore my lease is invalid. The answer is no. That is incorrect. If you sign the lease and you agree to abide by the lease and you pay for the lease, you pay your first month's rent, you pay your deposit, you are in the lease, whether they sign it or not. Whether they've given you a copy or not. They should always give you a copy. And if you don't have one, do not be afraid to ask for one. And do not be afraid to ask them multiple times. Sometimes they forget, sometimes they're just obstinate. So you want to make sure that you get your copies of your lease. But just because the landlord hasn't signed it or you don't have a signed copy does not mean that it's not a valid contract. Please keep that in mind. So a couple of lease pitfalls to keep an eye out for. We talked a little bit about this, the termination of the lease. But the typical residential lease ends after a year. But keep in mind that you need to know when your renewal period is. And a lot of student leases especially auto-renew. So if you are not planning to stay more than a year, or if you don't know if you want to stay more than a year, I mean, I'll be honest, and I don't want to scare people, especially since I know a lot of you are just moving to town or moving into a new place. A lot of places look great when you see them and then are not when you move in. It happens. It happens all the time, and it sucks. And I agree that it sucks. But don't assume, oh, I'm going to live here for the next 3 years. Always know when your renewal period is. Do you have to renew? Does it auto renew? And yes, an auto renewal is legal. A lot of people say, well, you can't force me into a contract. No, you signed an auto renewal. If you have to give them a specific amount of notice, do not wait until the last day. If you have to notify them by April 1st, do not mail it out March 31st. Yes, that is legal. Under the mailbox rule, under the laws of Pennsylvania, yes, that is legal notice. But do the smart thing and send it out the beginning of March. Make sure that they got it well in advance. Security deposit, after you end your lease, your landlord has 30 days from 2 triggering events. Both have to happen to start the 30-day counter to get you your security deposit back, or tell you why you're not getting it back and give you written reasons why not. Those 2 events are giving the keys back. That's number 1. And number 2, giving a forwarding address. So both of those are listed in that first bullet point under security deposit. Keys returned, a forwarding address must be provided. Once both of those happen, that's when they have 30 days to either get you your security deposit back or give you written notice of why they're keeping it with a detailed breakdown, or a combination of the 2. You gave them a $1,200 security deposit. They're only keeping $600. They should send you a letter as to why they're keeping $600 and give you your $600 back. Always, always, always take pictures of everything, and not blurry pictures. So for those who are looking at Zoom right now and can see me, I just took a picture that I see all the time come through. It's going to look like a blank white screen, and I promise you it is a blank white screen, because I just took a picture of the wall. And a lot of times people will take a picture of the wall where there's a scratch and go, look, there's a scratch in the wall. It doesn't mean anything. I don't know where that wall is. I don't know what I need to see. The difference being that this picture that I'm about to show you at least shows me that it's in my conference room where the chair, it's the wall where I have the picture of the courthouse. You need some frame of reference for your photos. Just taking a picture of a spot on the carpet does not tell us anything about that spot on the carpet. How big is it? In your photo, it looks like it's 2 feet across, but in reality, it's the size of a quarter. You need some kind of photographic evidence, and it needs to have some kind of a scale. You want to do that when you move in, so that you know exactly where any damages are, so that you're not charged for them when you move out. And you want to do it when you move out. And it doesn't matter if you didn't damage the property, take pictures of everything. Because that way they can't come back and go, well, you damaged the carpet. And it turns out, no, they damaged the carpet when they were trying to repair, they were replacing the stove and the movers damaged the carpet, but they're going to charge you because it's okay. No, you have photographic evidence that when you moved out, that carpet was pristine. So make sure that you have photos of everything. So this kind of goes back to that same slide before. It kind of gives you the citation of the Landlord-Tenant Act in Pennsylvania. We follow the Landlord-Tenant Act of 1951. You don't need to worry about the 68 PS. That section right there, 250.512, is the security deposit law. And that gives all these rules that I just discussed a little more broken down and a little bit more in depth. Here, if you wanted to read it, it's right here for you. The one thing that I always point out to people is this section B. Section B and I think it's section C. B says that if they fail to do this, if they fail to provide you a written list of the damages within 30 days, they should not be allowed to keep your security deposit. Now, the big word there is should not. I'm in the middle of a court case where they waited 3 months, but there was a significant amount of damage. And my argument is you shouldn't be able to keep it because you waited more than 30 days. Their argument is there was so much damage, it took us longer. So there is some room for exception there. But count those days, keep track of it, send them, when you give them when you give them your forwarding address, my advice is to mail it, certified mail. You want to make sure that they have an address where they can reach you for the next 30 days. Technically under C, and I don't know if you can see that my mouse on here, but it does say that if they don't give you your security deposit back or a written itemized reason why they're not giving it back, technically you can go after them for double your security deposit. So that $1,200 security deposit, you go after them for $2,400. Do the courts award that? It's rare. It's very rare. Only for the most negligent of landlords. But keep in mind that there are some remedies for you, the tenant, in these situations. There is the possibility that your landlord is not doing what they're supposed to be doing, that you can be compensated for that. In those situations, I'm going to say it. I've said it before. I'm going to keep saying it. Come talk to us. It's what we do. So I'm going to round this out with the termination of a lease. We talked about the lease ending on its own, whether it's the auto renewal that you sent them notice saying, I do not wish to auto renew. I do not wish to renew with the renewal period. Please turn off the auto renew. And you said that in time. Or your lease ended without an auto renewal and you chose to not renew it. Those are the two most common ways that these leases end. But we're going to talk about the three most common ways that a lease can be terminated early with minimal liability. The first is breach of contract. So we're going to talk about by the landlord and by the tenant. But when we talk about breach, we have to talk about the two types of breach: material and a limited breach, a minor breach. This is no joke. I had somebody come in. I will say, because we do this with other schools, this was not from CMU. So I'm happy to report this was not a CMU student who came and asked me about this. They wanted to breach their lease, and I said, well, what has the landlord done that we can use to say they breached the lease and therefore you should be allowed out of it? They said, well, our light in the kitchen went out a month ago and they still haven't come to replace it. And I said, so is it a specialty light? Is it, some kind of $200 bulb and some kind of, that you need an expert? They said, oh, no, it's just a regular light. And I said, okay, good. Go to Home Depot, go to Lowe's, go to Rite Aid, buy a light bulb, replace it. You're done. Our meeting is over. That's a minor breach. you're not going to get out of your lease for that. And yes, I swear that is an actual case that somebody brought to us. If you take a look at the right side of this slide, the limited breaches, leaky faucet, broken light fixture, the rooms are drafty, it's cold. Not cold as in unbearably cold, but it's nice out, and when there's a wind, it's a little chilly. No, that's not a reason to breach the lease. Breaches by the tenant, normal wear and tear of the property. If you've lived somewhere for a long time, or even a short amount of time, there's going to be things that happen. If you walk on the same carpet with your shoes on every day, the carpet's going to get dirty. It's not a reason to evict you. Did you pay rent on the second instead of the first? Fine, it's not a reason to evict you. When the landlord does breach with those limited breaches, with those minor breaches, you may be able to withhold your rent until it's fixed. You may be able to fix the problem yourself and reduce your rent. It does not reach the level of breaking your lease. If you cause minor damage to the property, you tripped and fell, and whatever you were carrying dented the wall, and they have to just bring somebody in to repair it, they may charge you for that, and they can charge you for that. It's damage that was caused, but they can't break your lease. They can't evict you for something like that. But looking at the left side of the slide, let's talk about the material breaches. Uninhabitable property, non-working plumbing or electrical, not giving you the property. When you show up to move in and they go, oh, sorry, the old tenants never moved out, I can't give you the property. You can't move in. Breaches that you're doing, so you're not paying your rent, you caused major damage to the property. You are the reason that the plumbing got pulled out. You had friends over who were a little inebriated and decided that they wanted to punch through the wall and destroy the pipes. That may be a reason to evict. Now, if it's the landlord's fault, so the uninhabitable property, the broken plumbing or electric, you may be able to withhold your rent. You can move out without penalty. Again, talk to us first, give us the situation so we can tell you the best steps to take. And you can sometimes even just completely cancel the lease. If you are the reason for the breach, they can evict, they can send you to collections. I don't have it in here, but we do sometimes talk about uninhabitable property, and I'm going to jump 2 slides real fast. And it talks about it in here as well, constructive eviction, which I'm going to discuss in a minute. But that's when I'll talk about uninhabitable property and how that's determined. So I promise I will get to that. One of my favorite areas of law when it comes to breaching contracts, and I know that sounds weird, and yes, my wife and kids tell me all the time that I have weird things that I like. Efficient breach is one of those really, really interesting areas of law. In here, we talk about a baseball bat. I'll go a little bit bigger and talk about a car. I promise to sell you my car for $5,000. I say, come back on Friday. Today's Monday. I need to clean it out, get all my stuff out of it. Come back on Friday. I'll sell it to you. You bring $5,000 and I'll give you my car. So you come back on Friday and the car's not there. And I go, oh, you know what? I sold it to somebody yesterday for $7,000. Sorry, bye. So what do you do at that point? You're out this car. We had an agreement. How can you satisfy that agreement? So you jump online, you go back to the same way you were looking for the car. You find the exact same type of car, the exact same condition, but only it's being sold for $6,000. So what do? You buy it for $6,000 and you sue me for the extra $1,000. You were already planning on spending $5,000. You're not going to get reimbursed that $5,000, but you had to spend an extra $1,000 to buy the car. So you can sue me for that extra $1,000. Why is it efficient breach? Why is that allowed? Because everybody benefits in that economy. Because in that situation, I sold my car, which is what I wanted to do. The person I sold it to bought the car that they wanted to buy. You got the car you wanted and you were made whole. I put an extra $1,000 in my pocket. You are not out any extra money because I had to give you that extra $1,000. So I made $2,000. I give you one of it. Now you have been made whole. You spent your $5,000 and I gave you one back to cover the sixth. I made an extra $1,000. Everybody has the cars that they want, and the deal is done. How does that apply to landlord-tenant cases? Your ceiling falls in. Through no fault of anybody's, but there's a leak and a piece of the ceiling falls in, and now there's a hole in the roof and you cannot live in your room. So what do you have to do? The landlord says, it's going to take me 3 weeks to get it fixed. The roofer's going to come out. They're going to fix it. It's going to take 3 weeks to fix. Figure something out. So you go stay in a hotel. And that hotel costs you $100 a night. You're spending $1,200 a month on your rent, and now you have to spend $2,100 to go stay at a hotel. You will get, if you sue your landlord for that money back, if they're not already offering to pay for it, you will get back over and above what you would have already spent. So 3 weeks at $1,200 a month is $900. You should get $1,200 of that $2,100 back. That's the way that it should work. If you had already paid your rent and your $1,200 for the month, you should get the full $2,100 back. Efficient breach just says that somebody has breached the contract, but everybody is made whole in the end. If you take a look at the last line of that efficient breach slide, not all breaches are bad. If everyone is able to get what they want, a breach can be good. And sometimes the law says that that's okay to do. And then finally, constructive eviction. There's two primary ways that constructive eviction can happen. The first is limitations that interfere with your enjoyment of the property. You move in and your landlord says, oh, by the way, and actually I've had this situation arise. You rent a house and and it's a 4-bedroom house and there's only 3 of you, and the landlord says, oh, by the way, I'm moving in too. And you can't use my kitchen, and you can't use my dining room, and you can't use my living room. You're renting a room, even though you were supposed to be renting the whole house. That's constructive eviction. They're basically forcing you out. They're forcing you to lose more and more of your rights that you had already gotten under that lease. That is a reason for you to terminate the lease. The second is not taking actions which permit the deterioration and decay. So if something needs to be fixed and you let them know, hey, piece of the ceiling fell in, the toilet doesn't flush, has never flushed. There's something broken, there's something wrong, something's happening. And the landlord says, oh, well, deal with it. That's constructive eviction. If it's causing a problem, if it's the carpet's dirty, then the answer is, oh, well. But if it's something that's going to cause damage to the property and possibly to the people in the property, that's constructive eviction. Another example that we see all the time, and this was a big issue for people in Bakery Square a couple of years ago. For those of you who aren't familiar, that's over by East Liberty, where Google's headquarters, Pittsburgh office is. There were a number of people in the Bakery living area who, when they found their apartment and they moved in, everything was great. Everybody was happy. They all moved in August. And then in September, Bakery Living decided to build a new building. And there was construction equipment outside from 8 o'clock in the morning till 8 o'clock at night. Now, under the law, that's okay, because the noise ordinances say that from 8 o'clock to 8 o'clock, they can be making that noise. But that's not what people signed up for at Bakery Living. That's not what these people signed up for. They didn't sign up to live next to a construction site. So that's an issue as well. That's constructive eviction. And that you can talk to Allegheny County Code Enforcement. you can talk to the health department. And those are reasons to breach your lease. I also know I know I promised you I would also talk about uninhabitable property, because people come to me all the time and say, I can't live here, it's uninhabitable. And I say, okay, but there's a legal definition for uninhabitable. The health department has a list of rules, and they come out and they check the property against those rules. And if there are certain violations under certain codes, then they deem it as uninhabitable. I had a client who lived in an uninhabitable property, what was deemed uninhabitable, and it took them time to move out. They didn't have the funds to move out. They were living there. By the time we got to court, they owed over $10,000 in rent. But because we had these letters from the health department that said this place is uninhabitable, these people should not be living here, and this landlord should be moving these people out of the property. They should help them move. The entire $10,000 was wiped away clean. My clients were very happy. I was very happy. Landlord wasn't, but that was their own fault. So don't assume that something is uninhabitable because it's a situation that you are not happy with. We live in Western Pennsylvania. This is something I had to get used to. We have mice in Southwestern Pennsylvania. We have them all over the country, but it's not, there are a lot of rural areas, even in some of the more urban and suburban areas. There are a lot of wooded areas. Frick Park is huge. Shenley Park is huge. We get critters. It happens. Just because you see a mouse in your apartment does not mean that you can breach your lease, that you can break your lease. That's not a thing. An infestation is different. These are all things to keep in mind. But again, come talk to us. We'll let you know if it's worthy of calling the health department, or even if you think it might be worthy of calling the health department, call them. Tell them to ask them to come out, and they'll come out and take a look. So what I'm going to do at this point, that ends the presentation. I do want to leave this slide up for a minute before I stop sharing my screen. We're not going to answer questions just yet. I'm going to stop the recording. I'm going to go through the chat. And I'm going to see what questions there are, and what we can answer today. But I do want to leave this out because one of the, other than landlord-tenant questions, the number one type of question that we get are immigration and international student questions. Neither Attorney Marcello or I are international attorneys or immigration attorneys. We have a little bit of knowledge that we have learned through our years of practice, and we have great attorneys that we can refer you to. However, before you contact us, before you contact the Slice office to request a consultation, we always ask that you speak with Linda Gentile or someone in her office. She's the Director of International Education. Talk to her office first, because 100% of the time, if I can answer the question, they can answer the question. And probably 75 to 80% of the time, they can answer the question without you ever having to talk to one of us. So I'm leaving this up just while I'm talking about it, so that if you have questions, or you might have questions, I want to give you an opportunity to write this down, take a screenshot, whatever you need to do. But this should tell you, these are the people that you should talk to first with international questions. If they cannot answer it, then schedule an appointment, or the other option is you can contact the Slice office and let them know that you have an international issue and you would like a referral to an international attorney. They have contacted us in the past, and we've passed along those attorneys' information, and then you don't have to spend 20 minutes or take out time of your schedule for something that we're just going to give you a referral to anyway. So you are always welcome to come talk to us. We are always happy to talk to students, but I always want to give people that heads up that if we can't answer the question, we always have people who can. But if it's an international or an immigration question, talk to Linda's office first before you do anything else. So I'm going to end the sharing, the screen share. I'm going to come back here, and I'm going through the chat. So right now, I think we have 4 questions that have been asked so far. So I'll jump into those 4 and we'll see what happens, from there. But yes, the question that I'm not counting, yes, these slides are going to be made available after today as well as the video. So I'm going to stop the recording now. I want to thank everybody who's watching this recording. And if you do have questions, please contact us. For those of you who are here live, give me just a second to stop the recording, make sure that I don't have to click anything through on my computer, and then I'm going to start answering questions.